My name is G.K. Ganesan and I am a practicing lawyer in Kuala Lumpur, Malaysia. Welcome to another episode of legal consequences and issues relating to the coronavirus pandemic. Today's topic is, are temporary workers at risk during the coronavirus lockdown? And before I go any further, could I please thank Mr. V.K. Raj, who helped me with the research for this particular video. Must daily paid workers be paid their wages during the pandemic lockdown? The answer is yes. Why? Well, the law is very simple. It protects all employees, whether they are casual employees or daily paid employees. They enjoy the same protection under the law. So what is the legal status of a daily paid or daily rated worker? Well, the question is whether or not a daily paid worker is different from a permanent employee. Remember, when you come to the office very early in the morning, you see a lady sweeping the floor or vacuuming the office or cleaning up after you leave. They are generally not employed by the company. They are employed by somebody else. They work on a daily basis. They may be employed by somebody else, but what about people like them? The law says such people are employees. There is a very famous case in 1985. It's called Cocoa Industry, and where the court ruled that under the relevant act, there is no difference between casual workers, temporary workers or permanent workers. They are all workmen, including apprentices and probationers. So there is your legal answer. Now, if you want to be a bit clever, you can go a little deeper. So the first question you should ask yourself is, in law, who is an employee? Who is a casual employee? The law is explained this also. A casual employee is one who offers himself for work at the job site daily, and if he is given work, he is paid at the end of the day. But where workers are assigned different kinds of work every day, but they are only paid at the end of the month, then that would give rise to the implication that that person is not a casual worker but an employee. A temporary worker is someone who is employed for a fixed term. For example, if someone takes maternity leave, another person comes to substitute that person. That person is a temporary employee. The employment of that person lasts for as long as the maternity leave lasts. Or if a company wants to conduct a market survey, and for the duration of that market survey someone is employed to do that market survey, that person is a temporary employee. But what is a real acid test? What is a real test between a contract of service and a contract for services? This is really very confusing and it gets everybody confused. The trick is this: a contract of service and contract for services has only got two words which are different from each other. The first one is of, has got two words. The third one is for. The lesser the number of word means employee. Where it's a contract of service, there is a master servant relationship between the worker and his employer. In a contract for services, that person is an independent contractor. Note the word for. He is being paid for his services. He is not an employee. But the difference between the two, as I said, can be so confusing. In a 1952 case, Lord Denning himself said it's not easy to recognize a contract of service when you say it. So how do you find out what is a contract of service? Employer, employee, and a contract for service, independent contractor. Well, they all started using different tests. In 1960, In a case called Chai Hin Company versus Public Prosecutor, the court was asked whether or not a company had to pay EPF contributions to some individuals. If they were employees, of course they had to be paid EPF compensation. If they were not, if they were independent contractors, there was no necessity to pay EPF contributions under the law. So what the court did was it used a legal tool. It said the tool is going to be called control and direction test. So if someone was the boss or the employer and he controlled and he directed the worker, then there was a relationship of master and servant. But over the years, this control and direction test in Chai Hin became very unsatisfactory and difficult to apply, and the courts in many different areas and eras tried to come up with a good test. Lord Denning, in a case called Stevenson, Jordan and Harrison versus McDonald, said the control and direction test is not so good, but the question anybody should ask is, was this man part of the business of the employer? If he was part and parcel of the organization, then he was an employee. That was the test, and that was emphasized by Lord Denning in another case back in 1953 called Bank War Handel versus Slatford. Now let's see how this test works. Have you been to a circus? Have you seen a trapeze artist? These people who fly up there in the ceiling using strings and ropes and stuff? Well, that's a trapeze artist. There's a lady called Ann Whitaker, and she was a trapeze artist, and a circus company called her and said, can we engage you? They didn't say, we'll employ you. They said, can we engage you? Could you please do trapeze acts because you're so good at it? She said, fine. Then she also said, before the trapeze act starts, could you guide the patrons into the hall and tell them where to sit? So she was an usherette. The question was, at the end of the day, was she an employee or an independent contractor? So in that particular case, the court felt that she was part and parcel of the business of the circus, and therefore she was an employee. And the name of that case is Whitaker versus Minister of Pensions and National Insurance, 1967. The judge was Justice Makata. But come back to Malaysia. But many years down the line, 15 years later, the same problem arose in Malaysia, and it was in a sawmill. Suppose you take the word lawyer and you take out the L and put the word S, sawyer. A sawyer is a person in a sawmill who cuts and splits logs. You have a round log, you cut it, you split it, then you cut it into planks. Now, there was a man called Mat Juso. He was a good man. He came to work and did a very good job. He was a good person. One day, while he was working, he was injured. He lost 3 of his fingers. So what do you think a person will do if he's lost his 3 fingers? He will ask for compensation. He will ask to come back for work. The company said, no, he's not our employee. It was a 1982 case. It was called Mat Juso bin Daud versus Syarikat Jaya Seberang Takhir Sendirian Berhad. So he went to see a lawyer and they sued the sawmill, and the sawmill said, look, Mat Juso is not our employee. We employed a guy called Lim. Lim brought him to work, so he is Lim's worker. He's not our worker. So the court used the part and parcel of the business test and said the work that Mat Juso did was an integral part of the sawmill business. It was part and parcel of the sawmill's work. He cut the logs, he split the logs, and that was part of the sawmill's business. Now he supplied his service and skill to the sawmill and not to the contractor Lim, and therefore the court decided that he was an employee, and the court found that the supervisors of the sawmill would come out and say to the sawyers, these people who cut logs and split logs like Madjuso, this is how much, so how many pieces you have to cut, this is how many tons you have to do, you have to clear out so much stock, and they were directly giving instructions to Madjuso. That made Madjuso an employee, the court said. And so as you can see over the years, that control test earlier, you remember the control test, control and direction test, that lost much of its strength. And in the modern world, control is no longer an issue. Do you know, professionals, engineers, architects, lawyers, managers, doctors, most of the time they don't have an employer breathing down their neck giving them instructions by the minute, but some of them are employees. If you go into a government hospital, the person who's working there is an employee of the government. If you go to a private hospital, if that person is a junior doctor and he's not tied down with any contract for professional services, he is an employee, and therefore this control test is no longer very important. And so we started with the question whether temporary workers are at risk during the coronavirus lockdown, and I answered you by saying they are employees and they must be paid their wages and you can't just kick them out. Well, the reality of the matter is, whether a person is a temporary worker or is paid by the hour is not important. The question is whether or not that person is part and parcel of the organization. If he is, he's an employee. If he's not, he's an independent contractor. And so employers really do have to pay their temporary worker or hourly paid workers or daily rated workers. So that's it for this episode. Thank you very much. I hope you enjoyed it. Could you please make sure that you press like, comment if you have any, and please subscribe. And if you like this video, could you please share it with all your friends?